Welcome everyone to this Mills Reeve session on the JCT Design and Build Contract 2024. We will stay on topic for as long as we can, but the minor works version came out last week, so we may stray into the subcontract and the minor works, but the focus of the next hour will be on the JCT D&B contract. And if my slides click through, there we go. Delighted that Ed, Emma, Barry and Alan joining me today in delivering this seminar. There's a lot of us because we are planning to get through quite a bit this afternoon, and you'll see that we're breaking it down into an initial section on risk, then moving over to Barry and Alan who'll look at BSA and sustainability. Ed and I will sweep up at the end, and a bit of top and tail from me on intro and observations, etc. Before we kick off with the introduction, a couple of housekeeping points. The webinar is being recorded and it will be available after the event together with the slides. And if you have any questions as we go through the various topics, then please use the Q&A function. So moving on to the introduction and to set the scene for the next hour, I think it's worth bearing in mind that in 24, it's a very different world in the construction sector from the world that we were living in 2016. There's a lot more instability within the marketplace. Inflation is an issue which contractors are grappling with. Every day, the insurance market seems to harden. And the JCT has attempted to deal with a number of these issues within its 24 suite. The strapline that the JCT launched last year was that it is the next evolution in its suite of contracts rather than a revolution. And the good news is that the evolutionary nature of the change means that if you are used to dealing with a JCT 2016 D&B, the 24 flavour is very similar to the 16 flavour in that it follows the same structure with recitals, articles, so on and so forth. All of those things are still there. There are a couple of new clauses and a number of amended sub-clauses, and Emma, Ed, Barry and Alan will take you through some of those. And the JCT has fiddled around with some of the numbering so that it's consistent throughout. We had the odd quirk in section 7 that didn't quite follow the rest of the JCT, and they have addressed that. The JCT is also keen to let us know that it has modernized. And one of the things that we've welcomed with the new suite is that it is gender neutral, and that follows the NEC and some other standard form contracts. The movement to electronic signature within the marketplace generally with DocuSign, so on and so forth, and user feedback for the JCT has been, can you please take that into account? And they have done that, as well as an appreciation that email is by far and away the most common form of liaising between parties, and there's a new email provision in there. There are a couple of things to watch out for with email, and we'll look at those particularly around termination. And building safety and sustainability are two other key areas that that the JCT have looked at, and Barry and Alan will spend some time talking to us about those changes. The other approach that the JCT has adopted in 24 is that it has lifted certain provisions that used to hide away in the shadows of Schedule 2 within the supplemental provisions and brought them into the front end of the contract. One being collaboration that now has its own article, Article 3, and for many years that's been hiding away in the shadows in the back of the contract. That's come to the front end. And we understand that there will be a target cost contract as well that the JCT will launch later this year, no doubt to compete with the NEC's Option C, which is a very popular form of contract. And why the JCT taking this approach for these two elements? No doubt there's a bit of a play for UK government work that for a number of years, the NEC has enjoyed the lion's share of large capital project work that's procured by government. And these changes and the nod to the construction playbook that Alan will also deal with seems to us to be a play by the JCT to win some of that work back from the NEC. So before I move on to Emma and to ask Emma to lead us through some of the liability changes, one point to bear in mind, I've mentioned at the beginning of this slide that JCT sees this as the next evolution in its journey. And we just raise a question mark around that. Our thought is that there are a number of material changes within JCT 24. So just bear that in mind as you hear from the four key speakers as we go through some of the points we want to discuss next. So Emma, if I hand over to you on liability, and if you take us through maybe a few of the key changes that the JCT have adopted in the 24 suite.
Thanks, Stuart. So I'll start with clause 217.1. This was the duty of care for design. The 2016 JCT language was, however, commonly amended to the market standard reasonable skill care to be expected of a professional undertaking work similar in a nature, scope, and location to the works that hopefully we're all familiar with. This clause has now been split in two. The first part mirrors the first part of the original clause, but updated to include clearer drafting and the more usual market standard language that I've just mentioned above that we're all familiar with. The principle remains the same there. The second part, however, contains a significant change with two parts. The first being that to the extent permitted by statutory requirements, the contractor shall have no greater duty of care than the reasonable skill and care mentioned above. So what does this mean? Does it mean it's okay to impose a different standard of care, providing that there's no prohibition on doing so in statute? In which case any different standard would need to be expressly stated in the contract, and we'll come back to that shortly. Alternatively, does it mean that the reasonable skill and care obligation applies unless statutory requirements impose a different standard which overrides the contract? That might create a degree of uncertainty. There is a need to clarify this, and bearing in mind that statutory requirements will include the standards imposed by the building safety legislation, even more so. The second part of it is that, and under no circumstances will the contractor be subject to any obligation that requires the design to be fit for its purpose. The and in this sentence means that the fitness for purpose exclusion appears to stand alone from the first part of the clause. In other words, it applies regardless of the contract or of what the contract or any statutory requirements say. And there's clearly some potential for conflict there. The fitness for purpose exclusion touches on a number of other threads in the contract, such as the requirements set out in the employer's requirements, any performance specification or requirements, or KPIs in the contract, such as those related to sustainability and environmental obligations, or design elements such as fire strategy. It will also touch on liability for materials being fit for their purpose. And there's an interface here with the Building Safety Act again, and any other fitness for purpose obligations imposed by statute. These changes potentially impact the overall allocation of design responsibility, noting that recital 3 and clauses 210 to 216 have not changed. The contractor's proposals must meet the employer's requirements. But what if there are obligations in the employer's requirements which are, or could arguably construed as, fitness for purpose obligations? Then this clause creates room to argue whether such obligations are subject to the fitness for purpose carve-out. If this clause remains, then it would be prudent to expressly identify any such obligations and carve them out to ensure there's no scope for argument over which standards apply.
Emma, thanks. That's a really interesting point. I just want to pick up on that language, the any such design wording that JCT have introduced into this exclusion of fitness for purpose. So if within the employer's requirements, there is a warrant that the works will satisfy certain performance requirements, or the contractor is delivering an off-site manufactured product, such as a bathroom pod, etc., could the employer walk around the any such design wording by arguing that the ERs impose a mandatory obligation which is separate from 217.1.2, and therefore try and hold the contractor to the fitness for purpose type of obligation in that situation?
Good question. I think there's ambiguity in the drafting here that either party could look to rely on. The employer might argue that any contract specifications sit outside of the exclusion, and the contractor will similarly argue that they do not. It's hard to believe the clause is intended to override clear requirements, but there is ambiguity here, and it's going to be in both parties' interest to clarify this.
Okay, so something to watch out for within 217.1.2. Another tweak that the JCT have introduced is that the good word diligence has fallen away from the reasonable skill and care clause, and I've spent many a long hour arguing that that's an important word and ought to be retained within a reasonable skill and care clause. Is there anything material in that deletion?
Well, there's been a body of case law on what diligence means in the context of a construction contract, and it seems likely to be interpreted as a time-related obligation, which could be covered elsewhere in the contract, for example, by the obligation to carry out the works by the completion date. So in other words, probably not a change to be concerned about here. I'll also move on to mention liability caps. So although there are no changes to the contract terms in JCT 24 on liability caps, there is a note in the accompanying guide about including an overall cap on the contractor's liability. And it goes as far as to suggest drafting for an overall liability cap and the relevant amendments that you'd also need to make in the contract particulars. The cap is drafted as a simple overall limit on liability with carve-outs for defective Premises Act liability, fraud, bribery, corruption, liability for death, personal injury, damage to property, and notably liability for liquidated damages. The guide says the cap on liability for loss of use under 217.3 is separate from any overall liability cap. And the guide suggests that 217.3 should be marked to not apply if an overall liability cap is used. I'll also go on to mention a couple of changes in the insurance provisions. The obligation on the contractor to maintain PI is now subject to cover being available not only on reasonable rates, but also on reasonable terms. And we think this reflects what has become a market standard position. Secondly, where option A applies, which is joint names insurance by the contractor, a new clause has been added which expressly gives the contractor the right to claim additional time where they are carrying out reinstatement works. The entitlement to additional payment is unchanged and remains limited to amounts received under the insurance policy. Previously, reinstatement work was only expressly stated to be a change for options B and C, or where loss and damage was caused by an accepted risk, which remains the case. Accepted risks being radiation, pressure waves, and terrorism not covered by insurance. So we view this change as a clarification to remove any scope for argument that the contractor has accepted the risk on time by using option C.
Emma, thank you very much. A couple of key things there just to bear in mind for anyone who thinks picking up JCT off the 24 off the shelf is fairly straightforward. Some additional risks there that parties need to be aware of. And thinking about risk, Ed, just bringing you in on the commercial risk, and it always worries me when I see that you have an introductory slide within your section. So Ed, you just want to give us a quick overview as to the areas that you will cover in this particular part of the session.
Thank you, Emma and Stuart. Yes, I've inherited the rather wide category of commercial risk, and by this I largely mean looking at those provisions which govern the contractor's potential entitlement to more time and money, and the direction in which they've travelled in the new JCT 2024 D&B, which, as you will see, I think has been in one direction. Whilst the changes to the JCT might at first sight seem minimal or evolutionary, are actually quite significant for the unwary. So just looking at what I'm going to talk about, first of all, I'm going to look at the amended notification provisions, notification periods in respect of interim extension of time applications. Then I'm going to look at some of the changes to relevant events and matters, in particular the statutory changes, and then finally a quick comment on the fluctuations. So what I think JCT have described as a streamlined interim EOT procedure, I would probably describe as shortened and possibly tightened, certainly from a project manager, employer's agent point of view. From a contractor's point of view, the notification procedure is as before. The contractor gives a notice of delaying circumstances, either with particulars or with the particulars to follow as soon as possible. For the employer, though, the position is different. Previously, the employer had an ability to ask for such further information as it may at any time reasonably require. The time period, not only is this time period now limited to 14 days, but also this information must be given, must be reasonably necessary to enable the employer to reach an EOT decision. So two changes there, both in terms of the time period and in terms of the potential content of the request. The time period for the employer to respond to the contractor's application has also changed from 12 weeks to 8 weeks, although it has been clarified that this is 8 weeks from the later of the information that the contractor volunteered or the further information supplied at the request of the employer. So EAs really do need to be fully aware and careful about these changes.
Ed, thanks very much for that. I just want to pick up on a few points. The first is that something has not changed, and it's the contractor shall give notice of circumstances and shall give particulars of expected events. If the contractor fails to comply with that positive obligation, does it lose its right to ask for an extension of time for the relevant event?
Well, as you say, Stuart, JCT have indicated that their intention is not really to change the position with regards to conditions precedent. Having looked at Keating before this, I think the thought now, based on the most recent wording, is that making an application is probably a prerequisite to being granted an extension prior to PC. But obviously, in relation to extensions of time, there is that wrap up after practical completion, which give the contractor some comfort. In terms of just a sort of slight aside, in terms of loss and expense, there has been a recent Scots Laws case which has added weight to the argument that notice provisions may be CPs in relation to loss and expense. So perhaps a bit of a caveat and a warning there.
Okay, and then looking at some of the new wording that's come in around reasonably necessary, and JCT, certainly on the D&B version, doesn't require the contract to be, the program to be a contract document. So when the employer is attempting to assess the effect of a relevant event against actual progress on site, how far do you think this reasonably necessary discussion, or where could that end up, where the employer is asking for a logic link program, the contractor saying, here's a paper PDF copy? How do you think those two competing views may be resolved?
Yes, right, Stuart. Obviously, unlike some contracts, the JCT doesn't specifically require a program, certainly an updated program, like other contracts. And in fact, there is notes in the guide in correspondence such as Keating to say that whilst something like a critical path analysis might be useful, its absence doesn't necessarily mean that a claim's going to fail. So it really falls back on the EA needing to assess whether completion is likely to be delayed, and then making a fair and reasonable extension, and whether it feels it can do that. So I think that seems to be the position in relation to JCT as opposed to some of the other contracts.
But there could certainly be some tension around that particular new provision that's worked its way in.
I suspect there will be, yeah.
And also the 8 weeks, if the employer or the EA doesn't quite get to something within 8 weeks, is there a deeming provision within the JCT?
Yeah, I mean, there's case law in it. There's been case law on this in the past. I think the general indication is that the time periods are not conditions for the employer, and it won't set time at large. But why take the risk? I suppose is the position there. You may end up with a dispute being generated and adjudication started. There might be other consequences for the contractor, which they might seek to recover. So I think the answer is why take the risk? Make sure you're aware of the time periods.
Okay, that was really helpful. Thank you. So just moving on to your next point, was on stat powers.
Yeah, so what about the grounds themselves? Well, JCT have increased the relevant event grounds, i.e. the grounds on which contractors can potentially get extensions of time. And in a really big change, some of these grounds can also now constitute relevant matters, where the relevant selection is made in the contract particulars. Everyone will be aware it's effectively the tick box section at the start of the JCT where you can select various options. And some of those now enable you to effectively turn a relevant event into also being a relevant matter. One of the big changes, as Stuart has alluded to, has come in the context of statutory changes. People may remember that previously statutory changes in law, were largely dealt with in 2 locations under clause 215. The changes in statute introduced after the base date that required a change to the works, and in some cases a change to the employer's requirements, constituted a capital C change, meaning that the contractor would potentially get time and money relief. And then in relation to time, relevant event, if there's a government or local or public authority which exercised a power after the base date, then that would be a ground for extension of time, but not given entitlement to more money necessarily. So this has changed in three big ways under 2024. First, 215.2 remains, but a change in law after the base date will now almost certainly give rise to a relevant event, as well as potentially a change under 215, if, for example, the work's required to be changed. So it'd be interesting to see how those two interact in reality and practice. And second, as I mentioned, if the option is selected in the contract particulars, a change in law will also entitle loss and expense claims, money claims. And finally, the relevant event, which refers to these items, also refers to guidance issued by the Construction Leadership Council, and probably, although the wording could be slightly clearer, government entities. So many bespoke COVID clauses during the pandemic included reference to the CIC guidance to reflect restrictions on working conditions. However, this clause is a bit wider.
Okay, so looking at the new 226.8, which has two new limbs as you've identified on the slide, just picking up on the first of the new limbs around new legislation. When we discussed it before, that seems to be quite a broad new hook that contractors can rely upon. Is there any limit to the application, either if it's UK based or if there's a foreseeability test? Is it all general law? Is it specific laws that apply to a certain site? Maybe worth just expanding on that a little bit more.
Well, the provisions are quite wide. I mean, it's quite interesting that 2.26.8 just refers to the UK, whereas statutory requirements is wider and could potentially, I suppose, cover impacts outside of the UK. And I think the thing to emphasise here is the importance of the base date. That's a really significant date, which is a date which is again written into the start of the JCT and the contract particulars. There is no foreseeability test, but not to say that might not be drafted in or carried across from other contracts. But it's very much the case that the base date is the key date for assessing this.
And you mentioned that it could also be cash as well as time, and I assume that the 421.7, that's the hook under the relevant matter provision if the parties tick it in the contract particulars.
Exactly, that is the case. So as I said, there is an overlap then from the last point there in relation to the CLC guidance with in relation to epidemics. And so JCT have included a specific epidemic clause. If an epidemic arises or gets worse after the base date and affects the availability of people, materials, goods or services needed for the works, then there is a possibility of an extension of time. And it's worth noting, I think, in the launch event I attended, that although JCT indicated this was a move on from relying on the general force majeure clause, there is no restriction on the force majeure clause by reference to this new clause. Final big point I wanted to mention in relation to commercial risk is the change to clause 315.3. This clause previously provided a procedure in relation to antiquities, potential time and cost relief to the contractor in relation to those. It has now been expanded to refer to contamination, asbestos, and unexploded ordnance. As JCT contracts don't generally deal with ground risk, they often have bespoke amendments to deal with it. So parties will need to very carefully consider how all this now fits together with what they may have otherwise in the contract, and whether it reflects the risk allocation that they've agreed and priced commercially.
Ed, thanks on that. Again, let's just probably worth looking at the first of those new relevant events, relevant matters around JCT as plumped for epidemic rather than pandemic. Does that expose employers to any additional risk?
I think the general view is that pandemic has a much wider, possibly global connotation. but epidemic could be relatively localized in the place that it's affected by the work, where the works are being carried out. So potentially epidemic could have a could result in a greater likelihood of receiving claims than pandemic, which is something that people might bear in mind, because they might think it is just purely related to something of the scale of COVID.
And is there a geography link to that? So if there's an epidemic where the factory may be, could that give rise to a relevant event or a relevant matter?
It could potentially do, yeah. Well, it's been interesting to see how that comes out in the subsequently, but there is clearly, with the more localized connotations of pandemic, the possibility of something being more localized than if it was a pandemic.
Okay, and then on ground conditions, and for those contractors who are involved in refit, refurb, this is ground conditions, not existing structure risk. They've used a fairly generic term, contamination. Are there any carve-outs from the ability to claim more time and money in respect of contamination? And I'm thinking here, if there's a two-stage D&B, for example, where the contractor's had the ability to undertake its own surveys on site and has identified pockets of contam on site, how does that then work its way into the risk profile under the new JCT 24?
Yes, in relation to asbestos and contaminated material, there is a carve-out in relation to items which have been identified in the contract documents. So what it means is it's very important to think of all of the documents, not just the terms and conditions, but also the technical and commercial documents and the legal documents in the round. If, for example, a contractor should have been aware of certain contaminated risks due to, for example, involvement in a PCSA stage or due to receipt of a reliance set of reports, important that those items are referred to appropriately in the documentation, because there is no blanket foreseeability or imposition of knowledge test in relation to this.
Okay, and then finally, where most of the red pen seems to have made its way into JCT 24 is on your fourth item.
I think it looks quite a significant change. I think as a final point, if you're looking for the fluctuation provision, option A has now been deleted from Schedule 7, which looks like quite a big change. But all it means is that if you want to find that now, you'll have to go to the JCT website if you feel compelled to read it. So I think that's been quite a lot for me there, a lot of me speaking. So I think perhaps the time for drawing breath, Stuart.
Thank you, Ed. And Emma and Ed, thank you very much for taking us through liability and commercial risk change. I want to bring back to that question that I posed right at the beginning about JCT, the next evolution question mark. Certainly, I teed it up a little bit by saying it's our view that 24 is a little bit more than evolution. Whether it constitutes a full revolution, probably not. But there are material changes in the liability provisions and the commercial risk profile introduced within the JCT 24 that doesn't mean you can just pick it up off the shelf and carry on as if it was a 16 form of contract. So things to watch out for. So we're going to change tack a little bit and look at some of or a couple of the areas where the JCT has told us it's modernized its approach to the way in which we deliver construction projects. And the first of those, I'm going to ask Barry to talk us through some of the Building Safety Act changes. And this is something that since 16, we've been dealing with Grenfell, and there's been a whole host of legislation on the Building Safety Act that's made its way through over the last 2 years or so. And Barry, can you just talk us through how the JCT has tackled Building Safety Act in its new form?
Yes, thank you, Stuart. I think first off, I think it's worthwhile to mention that the market views are that the approach that has been adopted with the Building Safety Act changes are quite light touch. The JCT introduced a drafting to accommodate Part 2A of the building regulations that covers the duty holder regime. This now applies in addition to the CDM regulations. Looking at some of the changes in the contract, a new Article 7 is inserted to cover the appointment of the principal contract and the principal designer under the building regulations. In clause 2.7.2, the employer is now required to comply with regulation 11A of the building regulations. in clause 3.16, which previously only made reference to the CDM regulations, has now been extended to ensure compliance with the relevant duty holder obligations as it's set out in Part 2A of the regulations. And then the only other provisions that address the changes to the building safety regime are in clauses 2.17.2 and 2.17.3. These clauses references the Defective Premises Act, which we know now has changed to cover the new 15-year limitation period for claims on negligent design of dwellings. And I think another point worthwhile to mention is the contract does not set out the duty holder responsibilities. The duty holder regime covered in Part 2A of the regulations is not expressly set out in the JCT itself. There's mere reference back to specific parts of these regulations to be complied with. Regulation 11A, as referenced in clause 2.7.2, pertains to building information and requires the employer to provide building information that will ensure that the contractor has access to the relevant information. As to what type of building information would be relevant, this is not outlined in the JCT. The next point is the contract does not cover limitation periods. Same as the DMB 2016, the new JCT lacks an express limitation clause. So looking at clause 2.17.2 and 2.17.3, as I mentioned now, we know that the Defective Premises Act introduced an extended limitation period, which is 15 years for claims related to negligent design of dwellings. Clause 2.17.2 clarifies that if the works involve the design and construction of a dwelling, the contractor's design liability extends to liability under the DPA. On competencies, the contract is silent on this as well. It doesn't explicitly cover any requirements around competencies. Just as a refresher for everyone's benefit, a key part of the new duty holder regime is that everyone doing design or building work must be competent and demonstrate their competence to do the work in a way that complies with the building regulations. The competency requirements are set out in Part 2A of the building regulations. Anyone who appoints a person to carry out design or building work must take all reasonable steps to ensure that those they appoint meet the competence requirements for their roles. And these are set out in regulations 11F to G and 11J of the building regulations. Then lastly, there's also nothing on higher risk building. The new JCT has not introduced drafting on high risk building, so nothing further outlined on the golden thread or gateways. Parties are merely directed to the JCT website to look at the guidance if a project is going to be a high risk build.
Barry, there's an awful lot there, and you say that the light touch amendment is an approach taken by the JCT. Seems to me, listening to you, that you can sort of get to the duty holder responsibilities if you know what the relevant regulation is saying. But given that this has been stepped down, as I understand it, into the subcontract as well, is there any advice you could give employers, contractors and subcontractors who are using this new suite in order to introduce a little bit of clarity about the extent of duty holder responsibilities, the extent of the competency checks and the extent of limitation, etc.?
I would think there is, because the contract just merely references back to the parts of the regulations needed to be complied with. A lot more pressure will need to be placed on the technical documents to fill the gaps. If acting for the parties, I would say that you would want to consider express clauses in the contract that expressly deals with the regulation 11A of the regulation obligations, for example. Additionally, the technical documents, i.e. your employer's requirements, can be used to specify the necessary building information that the contractor must receive. And in further dealing with the lack of a limitation of the limitation periods, the parties must be aware of the extended limitation periods under the DPA and its implications to properly deal with this in bespoke amendments for clarity and avoidance of ambiguity. And then also looking at the competencies point, by addressing the competence requirements expressly in a contract can help to ensure clarity and compliance. Perhaps some options that can be considered are to explicitly incorporate the competence requirements by amending the contract and add a specific clause to cover these requirements, or perhaps create an appendix or schedule within the contract that outlines the roles and the responsibilities.
So maybe a little bit of a crutch needed for the JCT in respect of making sure it adequately covers all of the building safety provisions. And Barry, I know we've got HRBs on the slide as well.
Yes, as I covered that briefly, just to say that the contract itself doesn't introduce any particular drafting on high-risk buildings.
So that's another point to be aware of. Just another point, picking up on something that Ed talked us through about the stat power, stat requirements changes. There seems to be lots of legislation at the moment regarding Building Safety Act, and one thing that Ed touched upon was this foreseeability test. If contractors are entering into a contract where there is a change in law provision, but it's subject to a foreseeability test, can you see any wrangling between the employer and the contractor around that sort of amendment to the JCT 24?
Yes, as Ed has mentioned, the list of relevant events has been expanded to cover any change in law or a publication of guidance or exercise of statutory power by the government. There's definitely ongoing challenges. If you think about the changes to secondary legislations, this remains a moving target at the moment, and we can expect to see some further movements and guidance to be released in the coming months. As an example, there have been discussions about the need for double staircases in residential buildings above 30 meters tall. And when these further changes come into play and become effective after the works have started already or after the base date, which Ed mentioned earlier, the concern or risk is that it can potentially cause delay with associated cost implications, especially on current live and active projects. So the parties will be required to keep this in mind and properly plan and budget for these type of scenarios.
Okay, really helpful, Barry. Thank you very much. And moving on to the second modernisation theme that the JCT has looked at. And here I'm going to ask Alan to help me out a little bit. And Alan, you and I have discussed this before, and we've had a look through the playbook, which is issued by government, and it was clear to us that sustainability and the environment, etc., is at the forefront of the government's thinking in terms of delivering construction projects. Has the JCT embraced that?
Thanks, Stuart. Yes, absolutely right. So the construction playbook does place the need for sustainability to be at the forefront of design. In terms of how the JCT 2024 has dealt with it, there are two new clauses. There's 2.1.5, where the contractor is encouraged to suggest economically viable amendments to the works, which may result in an improvement in the environmental performance or the sustainability of a project. But I would note that the wording provided that no such instruction shall extend the contractor's obligation in relation to the design under the contract. So, nothing there that actually properly bites, quite discretionary. Secondly, there is clause 2.2.2, which states that the contractor is to provide the employer with all information reasonably requested in respect of the environmental impact of the supply and use of goods and materials on the project. And some people might be listening thinking that those provisions sound familiar, and that's because they've been lifted from the old Schedule 2 supplemental provisions, 8.1 and 8.2 respectively. So really, on the face of it, particularly looking at 2.15, as I said, the wording is quite discretionary. It doesn't provide for anything that bites. There's no real concrete sustainability commitments there from the contractor. And really, because it is so light touch, any requirements, any sustainability provisions would need to be probably addressed in the employer's requirements or in the KPIs. So it might well be the case if the ERs are robust enough that an employer could then benefit from the contractor's obligations under 221 and have sustainability incorporated that way. But as I say, the highlight is it's very light touch, and if the contract is to satisfy the construction playbooks need to put sustainability at the forefront, then some amendments and tweaks will be needed.
Alan, there seems to be a little story here that we've heard from Barry about to supplement JCT 24. We may need to do that for Building Safety Act, and the way in which you've led us through 215, which does feel like a very fluffy clause indeed. We may also need to supplement the ERs to deal with sustainability. If we do that, I'm conscious of the point that Emma raised earlier about the exclusion of FFP and the new 217.1.2. Is it likely that there could be a conflict between the employer's aspirations and the contractor's obligations under the contract, bear in mind this new clause that's been introduced by JCT?
Yes, Stuart, I think that's absolutely spot on. And as Emma mentioned, yeah, there is that exclusion of fitness for purpose under 217(1)(2). So that does naturally create the potential conflict with any sustainability requirements included in the ERs, depending on how they've been drafted. And really what it means is any sustainability targets, any KPIs will need to be drafted in such a way that maybe it's qualified by the contractor using reasonable skill and care, or qualified in some other way, or perhaps the fitness for purpose clause will need to be amended, just so we can carve out sustainability or remove it altogether. But either way, no matter how it's tackled, action will need to be taken when incorporating sustainability requirements, just to ensure that they don't fall foul of this explicit exclusion.
Thanks, Alan. I just want to touch on another point, not directly related to sustainability, but it touches on a point you mentioned earlier about KPIs and performance indicators. And the new Procurement Act comes into force in October of this year, and that for certain government contracts or contracting authority contracts over a certain threshold, that publishable KPIs will have to be included as part of the ongoing contract management and procedure. It's likely that, as well as health and safety KPIs, that we may start to see KPIs around sustainability and hitting green targets, etc. Is there anything in the JCT 24 at the moment that enables us to implement the Procurement Act and its aspirations?
Well, then again, nothing explicit. I mean, there are supplemental provisions in Schedule 2 that deal with performance indicators and monitoring, generally at Supplemental Provision 7, but there's nothing that would allow for, publishable KPIs, nothing that would indicate what they're supposed to look like or how they should be incorporated into the contract. There's nothing to, outline the consequences for non-compliance. So again, nothing in the JCT D&B 2024 in its unamended form that would sort of directly accommodate for those sort of provisions of publishable KPIs. But I probably should mention the Chancery Lane project. So that has produced over 100 precedent climate-related clauses for use in various contracts, including construction contracts, the JCT. And that covers a lot of topics such as net zero, energy usage, waste reduction, green leases, green transport. So a lot of those sort of big issues that are hit upon in the construction playbook. And it's quite an extremely useful resource, given the range of contracts that will be put in place on any given construction contract, that will assist in passing down climate-related obligations down the supply chain. So as I say, that's a very welcome resource for reducing emissions on a project. But it's not a complete panacea. Obviously, you can't just pop them in and hope for the best. The clauses need to be adapted to the needs of a specific project. And if we're using them, we would caution that legal advice is sought so that they don't fall foul of, say, the fitness for purpose provisions, for example. Yeah.
Alan, thank you. Again,
Thanks.
I think let's draw breath at the end of that little section and just remind ourselves that after the liability and risk section, evolution ? There's possibly a bit of revolution within the new JCT 24. And hearing from Barry and Alan on sustainability, and that there may be the need to supplement some of the front end changes that the JCT has introduced by including more specific provisions within the technical documents, the contract documents. It could be a case of devolution away from the JCT front end into the technical documents. So again, not quite a gradual change as evolution as a term suggests. Before we look at subcontracts and the minor works form, I just want to wrap up quickly on a couple of the other areas that the JCT have tweaked in its new form. And there's a lot in termination, and you can see on the screen that the notice provisions have been amended at clause 1742 of the contract, that if the contract particulars are ticked in a certain way, notices can be given by email. That seems to us to include a termination notice as well. And whilst email is very easy to use for day-to-day notices, where you are issuing a termination notice, either as a contractor or as an employer, or as a subcontractor under the subcontract form, this may be one that you want to continue to deliver by hand to ensure there's absolute clarity as to when the notice was delivered, etc. There are also new grounds for termination, no fault grounds relating to the epidemic and change of law wording that Ed has looked at. So those concepts have now made their way into Section 8, and to the extent they have an impact on progress of the works for a certain length of time, then either party can terminate the contract. And again, they are quite broad in their ambit, as Ed mentioned when looking at epidemics and change of law earlier. And employers may wish to introduce a degree of additional protection regarding these new grounds that have been included within the 24 suite. Most of the changes relate to payment under the termination provisions. There's a new clause 8.13 that introduces a new concept called the termination payment. We haven't had that before within the JCT, and commentators who looked at the 11 form and the 16 form queried whether all of the termination provisions and the payments that flowed from that fully complied with the various construction acts and the various guises of the act. To clarify the position, and no doubt based on user feedback, the JCT has grappled with termination payments and with the payment provisions under the Act. And termination payment has its own due date depending upon the ground for termination, whether it's led by the employer or the contractor. And similarly, the termination payment also has its own final date for payment. And if the employer doesn't do what it should be doing, then there are provisions with 8.13 to ensure that the payment cycle moves on, so that the contractor is kept in pocket if the employer sits on its hands. There's been a tweak in 229 to the LAD provision, picking up on the triple point decision that the right to recover LADs should cease on termination of the contract. That's now made its way into the 24 form. JCT hasn't grappled with the notice provisions in clause 229. There's a thought that maybe it's slightly overcomplicated with the number of notices that have to be provided by the employer before it can levy LADs, but there are no other changes within 229, so employers ought to watch out for potential traps around notices and LADs. And the final point from me, before we look at the subcontract and minor works, is another one of these lift and shift clauses that Alan mentioned earlier, and that also apply to the collaboration principles. The idea of attempting to resolve a dispute amicably, again, was hidden away in Schedule 2. That now moves into the limelight. It has its own new clause, clause 9.1, but there's no guidance as to how that particular provision works. So if that is in the contract and you are relying upon it, you may need to supplement how the way of resolving a dispute under 9.1 is implemented by including additional provisions within the ERs, just to give that a bit of clarity. So they are the key material points that we wanted to run through under the D&B 24 version. We haven't covered every single point, but hopefully we've picked out some of the material points for you to think about. I'm going to ask Ed just to briefly look at the subcontract and the minor works form on the next slide. So Ed, if I could hand over to you.
Thank you, Stuart. As you said, this seminar is largely focusing on the DB Design and Build 2024 amendments. We have a brief look at the subcontract and the minor works, which in particular is very hot off the press, only having come out very recently. For both, broadly, JCT have stepped down, mostly stepped down the DNB 2024 amendments in relation to things like liability, risk, and sustainability. A couple of big points to note on the subcontract, however. The indemnity in clause 2.5.2, under which the subcontractor indemnified and held harmless the contractor against claims, damage, loss, or expense resulting from negligence or breach of duty, is no longer there. And in its place in clause 2.5.2, there are new time-based limitations for 6 or 12 years, depending on whether your subcontract has been executed as a deed or merely underhand as a normal contract. Just in relation to the minor works, again, our look at it so far, it's only just come out, is that it's broadly flowing down the same provisions as the Design and Build 2024, although it's worth noting that some of the key provisions that I talked about before in terms of commercial risk are less relevant for the minor works, as, for example, the extension of time provision is very condensed in the minor works contract, and there is no specific loss and expense clause in the minor works contract. So that's really all I have to say on those two for now. But watch this space in the future for any further updates on the 2024 suite.
Thank you, Ed. So there seems to be a material change, particularly in that subcontract around 252, that contractors ought to be aware of. Okay, so a couple of final points. What's missing? Employers for a number of years have grumbled about the DNB doesn't result in a full transfer of design risk at the outset, and the JCT hasn't fiddled around with the key provisions that deal with that. We've heard from Barry and Alan on the Building Safety Act and on sustainability that although there's a bit of dot to dot, particularly on the BSA, but JCT hasn't really gone that far on embracing sustainability and ESG under its new 24 version. And the Procurement Act that Alan and I discussed that briefly when looking at KPIs, that when that comes into force in 24 later this year, October 24, no doubt the JCT will have to issue significant amendments to deal with that. And other things aren't in there, the VAT reverse charge. We haven't seen anything that deals with Section 111.10 of the Construction Act around payless notices and insolvency, etc. So there are a few things that that we would have liked to have seen that haven't quite made it through into the final cut. So as a final summary, next evolution ? It seems to be a little bit more than that, and we heard from Emma and Ed on the commercial risks that seems more revolutionary than even evolutionary. And similarly, listening to Barry and Alan on some of the modernization, yes, it's gone a certain step, but it seems to have devolved power to the technical documents, the contract documents, to fully and clarify the risks around BSA and ESG, etc. I suspect when it landed, there were more smiles in the contractor camp than the employer camp when the red line version was opened up on the day of publication. And no doubt there will be more arm wrestling between the employer's advisors and the contractor's advisors pre-contract to ensure that the risk profile mirrors some of the risks that an employer would expect to see the contract to include. And I've mentioned the missed opportunities in the earlier slide. One final question, or I'll leave you with a final question, in that the major projects form, which does have a more robust approach to design risk and the way in which it deals with meeting employer requirements, depending upon how the JCT proposes to amend that form, if the DNB sticks with 217.1.2 and it's impossible to persuade the contractor market and its insurers to move away from that, we may start to see employers, particularly on large capital projects, pick up and dust off the MPF form and to use that going forwards. So I'm conscious of time. We've got 5 minutes left, and there are a couple of questions in the chat. It may be that we've only got time for a couple of those, but let's have a go and see how far we get. So Emma, you mentioned that we now have the beginnings of a cap on liability in the JCT form, and you helpfully talked us through some of the sublimits that apply. How does the JCT's approach to the cap on liability compare with X18 of NEC4, which is the NEC4 cap on liability?
Yeah, so X18 is an overall cap on liability, which also provides for separate subcaps, including in relation to consequential loss. And that's the part that's quite different to the cap proposed by JCT, who expressly said, if you're using an overall cap, then don't separately cap your consequential losses.
Okay, but it has both have sublimits, and they carve out things such as delay damage and LADs as comparable an approach to risk for some of those sublimits and carve outs. Okay,
that's correct.
And maybe one more, Ed. Always like to give you the final word. You mentioned guidance and CLC, and there is no doubt that when we're all grappling with COVID, lots of the guidance that was issued by the CLC was incredibly helpful to keep the sites moving. But you and I had a quick look on the CLC website. It seems as if the tentacles of CLC are spreading. Does that introduce additional risk for employers who are happy to live with CLC guidance as a 226(8) entitlement to time and money?
I think you've said it, Stuart. I think on that, I mean, the definition
Lead the witness.
Lead the witness on that. I mean, because it's defined as the occurrence after the base date of any of the following. One of those is the publication of any guidance by the Construction Leadership Council or its successor. There is clearly quite a wide potential risk there, depending on what the Construction Leadership Council decides to publish in the future. So I think that's something that people need to be very aware of, and perhaps try and become a member of the Construction Leadership Council.
Great. Well, thank you very much for taking the time out of your busy afternoons to log into this webinar, and many thanks to Emma, Ed, Barry and Alan for all of the hard work that they put into their parts of the webinar.